Number 156, People versus Louis Pabon.
May it please the Court, Brian Schiffer on behalf of Mr. Pabon. I request to reserve 2 minutes for rebuttal, please.
You have 2 minutes, sir.
Thank you, Your Honor.
You're welcome.
Mr. Pabon urges that the 2012 commencement of his prosecution for course of sexual conduct was time-barred because it charged acts allegedly committed no later than 1999, but it was not commenced within 5 years of 1999 as then required by CPL 30.103E.
So, counsel, your argument, or one of your arguments, is that there's a conflict between paragraph E and F, correct?
That's correct.
Okay. What's the nature of this conflict, since F relies on another provision for the period of limitations? That is to say, if you read F, it in no place mentions an actual period of limitations. You must look outside of F to identify the period of limitations. Where's the conflict?
To appreciate the conflict, one has to go back. There was one statute passed in 1996 in which the legislature simultaneously enacted 3 different statutory provisions. First, it enacted for the first time course of sexual conduct, which created a new crime, which didn't have the specificity notice requirements this Court set forth in Kindle, and set forth F, which had a tolling provision, and E, which said for the first time and at the time the only provision for any sex crime, a 5-year limitation for this crime based on the last act. If the goal was to apply F to course of sexual conduct, the legislature would have only enacted course of sexual conduct and F because it would have achieved those purposes because...
When would the statute of limitations have run if the crime was reported?
If the crime is reported, that's F.
Would the tolling apply?
F doesn't apply at all.
F doesn't apply to that either?
The reason F doesn't...
So that would require that the charges be brought within 5 years of when it was reported?
When the act occurred. That was the way that statute was written, and there's a reason for that. For two different things.
When the act occurred. Okay, so if it was reported, if it wasn't reported until, let's say the act occurred when the victim was 5 years old, and it's reported when the victim is 11, right?
Yep.
Okay, so does that mean that the statute of limitations has already run?
The answer is yes, because there was no provision enacted with respect to course of sexual conduct to extend the 5-year period indeed.
Doesn't that defeat the purpose,
well,
though, of protecting these child victims?
Respectfully, the child victims were protected because, for instance, in this case, Mr. Pabon could have been charged with both sodomy and sexual abuse because those crimes were subject to F, and therefore both the reporting requirement applied and also the tolling provision applied. Indeed, he faced more time if the prosecutor and the grand jury chose to go that way, because each act could have been consecutive sentencing. Instead, and he was initially charged with that in a felony complaint. The prosecutor and the grand jury indicted only on course of sexual conduct to avoid the specificity requirements. When going back to the initial question as to why the difference between enacting 2 provisions or 3 provisions, if the legislature intended the tolling provision to apply, and if they need not have done E at all, because they would have achieved the 5-year statute of limitations.
I have a conceptual problem with what you're saying there, Mr. Schiffer. And the problem is that a tolling provision only applies if a statute of limitation exists. A tolling provision and the statute of limitations are 2 conceptually different things. First you have to have a statute of limitations before you can have a tolling provision. In this instance, even though there may be an overlap, there's not necessarily, it doesn't make it superfluous, but there may be an overlap between the 2. But you can't toll a statute of limitations unless you first have one to begin with. So there has to be one in place. It has to have some effect. If you're going to remove it, then you have to say that specifically. Otherwise, the tolling provision comes into play. And the fact that there are overlap doesn't necessarily negate the 2 of them. And to try and, it seems to me conceptually improper and a misunderstanding of what those 2 provisions are.
The E never would apply under any circumstances if F applies to this crime back in 1999.
What if the child is assaulted when the child is 7, They report to the state central register. Nothing happens as a result of that report, and the child is continued to be assaulted. What's the statute of limitations that applies?
The statute of limitations for continuing offenses has always been the last act. So for continuing offenses, and this is a continuing offense, it's always the last act. Therefore, again, E didn't change that. E didn't change the 5-year rule for felonies that are not A felonies, and E didn't change the requirement, the existing law that for continuing offenses, it's the last act that starts the commencement of the 5-year period. So that still, if there's continuing offenses as included in the alleged course of sexual conduct, the 5 years doesn't start running until the last act, which is why it's a superfluous nullity if you apply F, because the continuing offense language existed anyway, and the 5-year statute of limitations existed anyway. What was achieved by also enacting E, in addition to creating the crime, in addition to F, was saying because, and in these circumstances, we're allowing prosecutions without the specificity requirements of Kindle, we're adding a limitation on when you can do it.
I see your point on that, but because it does sound like if F applies, you don't need E. But why is that? Why don't we just knock out E? It seemed to me when they were passing that, they said, we want to protect the children. If you got two adults who choose not to report it, she's the mother, and the husband or boyfriend's doing this, but for reasons unknown to anybody, it doesn't get reported. If it's E, 5 years, she's out of luck, the victim. But under F, when she finally grows up and says, these two bad people did all this to me, and I'm now going to report it to the police. What's the bad part about that?
Two different answers. First of all, if that was their concern, they need not have even enacted E, because E never goes into effect if F applies. There's not a single circumstance where E applies back under the then 1999 statute if F applies.
No. Because F can't apply unless there's a statute that's being limited to begin with.
The statute that's being limited is already, for all felonies other than A felonies, is always a 5-year limitation. So there was already a statute of limitations for that crime. If I can briefly, if the court is not going to dismiss under that ground, it should be reversed under point 2, because it was error to allow the police officer over objection to thrice state his opinion that my client was lying when he denied his culpability.
What was the harm or prejudice in that? I mean, here you have a bench trial, and even though the judge's response to the objection was a little bit ambiguous, I'll certainly give you that. Can't we? Isn't there sort of a presumption that it wouldn't influence the judge in the way it might influence a lay jury?
Three quick answers. Time's running up. One, there is a presumption that evidence that's ruled inadmissible and not admitted is not considered. There's no presumption ever adopted by this court that evidence that the trial judge found to be admissible is not going to be considered by the judge who admitted it. This evidence was not admissible for any purpose. As I pointed out in my brief, in cases such as Cunningham and Maharaj, even though when a court makes an error in a non-jury trial and then says, well, it didn't make a difference, this court has never accepted that. And finally, because there was not overwhelming evidence of guilt, the harmless error analysis shouldn't apply. If harmless error analysis is applied under the circumstances, given every aspect of this case of the allegations which was capable of being tested were proved to be false, again, it was not harmless.
Thank you, sir. Counsel?
May it please the Court, Robert Shoemaker for the people. When interpreting the statute in this case, the Court needs to look to the spirit and purpose of the legislation. The spirit and purpose of the legislation in this case shows that sub-F does apply to course of sexual conduct against a child in the first degree.
Is he right, though, that it doesn't make sense, the two of them together?
I don't agree with that. I think there are certain cases, actually Chief Judge DiFiore did mention a circumstance that I put in my brief, where if the abuse continues after disclosure, then sub-E comes into effect, not sub-F.
Why? Why does E come into effect?
Because E says that you start the statute of limitations from the date of the last act.
Right.
So if that last act is after the disclosure, then E trumps F.
No. no. I mean, the big deal in F is the age, right? And it's that the victim, usually a woman, can bring it no matter what happens once she reaches the age of majority. So whether it's reported or not, whether it's the last act that was when she was 17 or whatever, the statute of limitations is at least going to be from the time that she's 21 plus 5, right? So E never applies.
Right, because it's from the time it's reported, right, even under F. So if you report it earlier, your clock runs even under F, right? But what about this situation, and I just don't know the answer to this, but if you have a course of conduct, no reporting, starts very young age but continues past 18. So would that be considered a course of conduct where the last act is, let's say, 19, whereas F would start to run at 18?
I'm sorry.
Is that confusing?
A little bit. I don't know if I know the answer either.
So, I'm sure it is. So if I have a course of conduct on a minor, but it extends beyond the 18th birthday, but it starts at 8, right? This is long-term abuse. Would the clock run at, let's say it stops at 19. Would the act at 19 be considered course of conduct for E? Or would you start the statute of limitations at 18, either way?
Just thinking about it right now, I would think that you would start the statute of limitations at the last act.
Which would be 19.
Right.
Which would give you a longer statute under E.
Yes.
Right.
Okay, so what, can I ask, why, you start out saying we have to think of the spirit and intent. Why do we do that? If, perhaps I'm misunderstanding this argument, I've missed something in both the sets of briefs here, or in the language of the statute. F doesn't have a period of limitations. There is no statute of limitations in F. F is a tolling provision.
Yes.
You always have to look external to F. Where's the conflict with E?
I don't think there is one.
There's no conflict from your side, but why are you telling us, that's what I'm saying, it sounded to me like you were saying you have to look at the spirit and intent, suggesting that there's some ambiguity or difficulty in simply looking at this as F is a tolling provision.
Well, someone thought there was ambiguity here, which is why we're here. There was a dissenter at the appellate division, assuming that the two subsections can't be reconciled. That's when we looked at the spirit and the intent of the legislation, assuming that E and F can't coexist, assuming that...
But this is my question. How can they not when F is not a statute of limitations? It is a tolling provision, and E is the statute of limitations. I could see the argument that F doesn't tell you which is the statute of limitations. That seems to me perhaps something that's got legs, but to suggest between E and F you're choosing the time in F or the time in E, unless I've misunderstood the defendant's argument, I don't see how you do that, because F has no time.
Yeah, I think I'm kind of taking the defendant's argument right now, but I think...
But tell me what the people's position is about how you read the statute.
How I read the statute is that F applies. And I think, I don't want to speak for Mr. Schifrin, but his argument is that E doesn't matter because the statute of limitations for all felonies was already written. So F could have simply told that instead of told this new subsection E.
Okay, so where is the other time period? Where is this other time period he's talking about?
The 5 years that applies to all...
5 years period.
That applies to all non-A
All right,
at the
now I'm
time.
better understanding that. Thank you.
Counsel, shifting gears a little bit, was the trial judge obligated to make a factual record in response to the claim by the lawyer of juror misconduct?
No, and I couldn't, honestly, I couldn't find any cases on that. The judge was looking at, it's unclear what he was looking at, but it looks like he was looking at some kind of police paperwork. And the defense attorney objected. The next day, I think he moved for a mistrial and asked the judge to sequester his cell phone, his computer, and basically anything the judge had been looking at during the previous day of the trial. And I cited in my brief, even though I couldn't find cases, I cited in my brief the practical considerations that would go against making a rule there. If judges weren't allowed to look at things, then you'd have a subpar judge in every bench trial.
But then what would be the remedy? Let's just say that the judge was doing something completely inappropriate, looking at something that wasn't in evidence or communicating with somebody that he shouldn't have been communicating. What would be the remedy for that if there's no record?
I'm not sure, but I guess For the first part of your question, it's okay that he's looking at something that's not in evidence. Let's say something's about to be introduced into evidence, he needs to know what that thing's going to be.
What if it was never introduced into evidence? It wasn't marked as an exhibit? There was no indication that anybody was going to refer to that, but he happened to have it, I don't know, through somehow from discovery or whatever.
I mean, I suppose the defense attorney could try to make a record, but then at the same time, we'd have this situation where in all bench trials, everything the judge looks at has to be made a record. You have to put everything in the record that the judge is looking at. I don't know if that's the rule that we want.
Well, is there anything in between that could possibly be a rule, or you're just saying when you balance it out, then we just have to assume that there was nothing improper going on?
For bench trials, we presume there's a presumption of regularity for trials, and if it is something inappropriate and the defense attorney brings it up, given that presumption, we need to presume that the judge will say that if something was
then it's an irrebuttable presumption, actually, isn't it? If we don't require a record be made of it.
Yeah, I guess that's right. We'd expect the judge to make a record if something is inappropriate, if he was looking at something inappropriate. I would like to touch briefly on...
Well, you got the record. What would be the point to object if not to, under your scenario, to preserve it for further review, right?
Well, there was an objection here that whatever...
No, I know there is here, but I'm saying the point of this, if you're really sort of following through your analysis in this, that anything comes in and the judge can sift through it, then the only point of objection under that analysis would be to preserve it for appellate review as opposed to for purposes of the cure?
I think the point of objecting would be to alert the trial judge that something's wrong. That's why we have a
So
contemporaneous...
if the judge indicates that he or she thinks there's nothing wrong, presumption is rebutted?
Yeah, it is.
And if the judge stays silent and says you have your objection?
Yeah, we still have the presumption of regularity. We have the presumption the judge is not looking at anything inappropriate. Which actually brings me to point 2 of the brief, which is what Mr. Schifrin talked about last, that there was no prejudice in the judge listening to the testimony of the police officer. There actually is a case from this court. It's not in my brief. I found it while preparing for oral argument. But I did show it to Mr. Schifrin. It's People v. Debate, D''A''B''A''T''E, 37 New York 2nd, 922. In that case, the prosecutor asked inappropriate questions on cross-examination. That testimony was admitted at trial, but this court held that the impropriety was not prejudicial, especially since this was a non-jury case. That's what the case says. It's a one-page opinion. So applying that case to these facts, there was no prejudice given, A, the presumption of regularity, that the judge is not taking anything inadmissible or inappropriate into account, and B, the fact that even on the record we have the judge saying, well, I'm not taking his opinion, I'm listening to his testimony.
Well, the problem is that how does a judge, who's also the fact finder, ignore facts that the judge erroneously admitted? I can see that if he was given facts and did a suppression hearing at a time, and of course he ruled on that, he would have heard facts that may or may not have been admitted. But at trial, the facts that are in the record, how would a judge ignore those facts that he himself admitted?
He did ignore it in this case. He said he was ignoring it. He said, I'm not taking his opinion, I'm listening to his testimony.
Right, but he didn't exclude them from the record. He didn't deny admittance, right? He didn't suppress his testimony. He didn't say, no, that's not admissible testimony.
Right, and maybe
So it's in the record, so he admitted it. So that means it's part of the record that he considers.
And maybe
It's an entirely different thing from the suppression of, say, a statement that he knows about, but it's not in front of him in trial because it was improperly suppressed before.
And maybe if this were a jury trial, he would have given the jury an instruction. But for non-jury trials, the judge need not
But what
instruct
instruction?
himself.
The instruction usually is you can only consider it for this limited purpose. And either that or the instruction is you must totally disregard it because it was erroneously admitted. Here, there was no legitimate purpose. So what would the instruction be?
Well, I don't know if I agree that there was no legitimate purpose. I cite in my brief a few legitimate purposes this testimony could have been admitted for. But I don't think he needs to instruct himself that you do consider what the detective is saying happened in the interrogation, but you don't need to consider the detective's own, or the investigator's own opinion that defendant was lying, and that's why he kept going. The fact that the investigator thought defendant was lying explains why the investigator kept going. The finder of fact...
You have a compelling argument here because the judge is saying, I'm not taking that, or paraphrase, I'm not taking his judgment. You have that compelling argument. But when a judge doesn't make that comment, it begs the question, why is the judge letting in something that should not have been let in? Let's say we don't agree with your argument about this being appropriately, that could appropriately have been let in. I mean, we're sort of stuck, aren't we not?
I don't know if
Why would a judge be letting in something that it should not come into evidence, but for purposes of considering that in evidence?
And you do have some cases that are actually cited in the reply brief where, I think one of them actually, the judge is the one who called the witness who let in the inadmissible evidence. In cases like that, where the record reveals the judge actually is taking into consideration something inappropriate, then the presumption of regularity is rebutted. That's in the reply brief. There are 3 cases, and that's page 10 of the reply brief. One of them, there was no explicit statement from the judge. One of them, this court said the judge clearly relied on the inadmissible evidence, and for the third one is the one where the judge actually called the witness.
If I may, because you've run out of time, with respect to the sequestration, did the judge have to put anything on the record?
No, I don't think he did.
Why not?
Because there's a presumption of regularity. He doesn't need to say
Same
what he's looking at.
regularity. Okay.
Maybe he's looking at the police report. Maybe he's, I put in my brief, maybe he's text messaging the administrator to ask for more time. He doesn't need to put that on the record.
Thank you, counsel.
Thank you.
Thank you. Mr. Schiffer, what was the basis for defense counsel's request to sequester or seize the judge's computer and his cell phone?
What happened is apparently the judge was reading the police officer's deposition, which was not admitted during the testimony of the police officer, in objecting to that as being improper. The attorney also objected at that point.
Do we know what he was reading?
Actually, good question. That's what the defense attorney claimed that the judge was reading. The judge never responded to that in denying both the objection and the mistrial motion. And at the same context, the attorney also noted, Your Honor, you also have been using your cell phone and computer, again objected to that, and all
What
motions...
specifically was it about the cell phone, for example? What's the basis for asking to seize a judge's cell phone?
Well, the problem is we don't know if it was being used for permissible or impermissible purposes. If the judge had simply put on the record, with respect to the document or with respect to the other items,
Do you have a threshold? Does the defense have a threshold burden? I think is what, in part, the Chief Judge is asking. That would then require the judge to put something on the record.
I would argue, clearly, whatever the burden standard might be, it was met with respect to the document where there was an allegation that it was a police report, not an evidence, and the judge was reading that which was not an evidence, which goes back to point 2, which is considering the repeated statement there's a presumption. The Smith case and the Arnold case cited in my brief were not decided on a basis of a presumption. This Court has never adopted a presumption that evidence that's been improperly admitted is not considered by a judge in a non-jury trial. In this case, there was no proper basis for admission, and it's simply absurd to say the judge who didn't know enough to not admit that evidence didn't consider the evidence for any purpose, because, again, as pointed out...
Well, he's not, the judge isn't, the guardian of the defense. I mean, maybe the defense wanted that information, and maybe they wanted to make the cop look like a jerk. And my only point is that you're saying, well, a judge isn't smart enough to know that that's not good evidence. I'm not sure that's true. And if it comes in and there's an objection, he can say, I'm not going to consider it.
It was objected to 3 times by the attorney. 3 times when the district attorney asked, why did you do this? And he kept on saying, because he was lying. Objection to the why questions. Not to what no objections to what was said to the defendant, but the officer's opinion was objected to. It was not admissible for any purpose, and therefore it's wrong to assume this judge didn't consider it for any purpose, although he did say he wasn't considered for the officer's judgment. There was no proper purpose to consider it, and under these circumstances, it was reversible error. Thank you, Your Honor.
Thank you, Mr. Schiffer.